Welcome to another episode of the Federal Newswire Lunch Hour podcast with your host, Andrew Langer.
Well, hey there, everybody. Welcome to another episode of the Federal Newswire's Lunch Hour podcast. I'm Andrew Langer, your host, and if you are not following us on X, please do so at the Lunch Hour Pod. That's how you can really stay up to date with everything that's going on, see clips of the shows, etc. But if you are watching us on our YouTube channel, please check us out. Take us with you wherever your fine podcast content is to be found. And if you're listening to us on one of those many fine audio podcast platforms, check us out in studio as well at our YouTube channel. Please do that. And as always, hit the subscribe button, leave a comment, leave a like, and let your friends and family members and your family members' friends know how much you're enjoying the show. Very excited to bring our guest on today. I've had a lot of fun chatting with him about what is a major sleeper issue. His name is Jon Bergner. He is the executive director of Americans for Litigation Tax Fairness. I know I'm going to butcher that, John, before the day is done. I'm gonna confuse the letters. But John, many years in the public policy world. He was for many years with John. Which trade association was it?
The National Association of Mutual Insurance Companies.
National Association of Mutual Insurance Companies. You're going to explain to us what that means as well. He's got an undergraduate degree from UVA, that little college up the road, as well as amazingly a master's in national security studies from Georgetown University. And John, I mean, you know, you and I both share that rare quality where we've never spent time. Now I don't remember. Did you spend any time on the Hill?
Very briefly.
Very briefly. You were an intern, right? You were an intern and then a junior staffer.
Correct.
But you've spent most of your time with the National Association of Mutual Insurance Companies. Did you ever think you were going to find yourself? I mean, you have the like me. I have a degree in international relations. Didn't really do much with the degree. How did you wind up in all of this?
You know, I was actually working at NAMIC at the time that I was pursuing my master's in the evening, and wasn't sure necessarily what I wanted to do with it. But ultimately, I was so fascinated with the work I was doing for NAMIC, doing federal government relations, and to answer your question about who that is, it's a trade association for property casualty insurers. So these are the folks that insure homes and businesses, your boats, your toys. Things like that, as opposed to life or health insurance. And frankly, all the issues on a daily basis were so different that it kept me intellectually stimulated. I was working on all sorts of different things. And once I graduated with the master's, I actually really got into one particular issue that was a very neat sort of synthesis, I guess, of my professional experience and my academic career, which was the terrorism risk insurance program that was set up after 9/11. So I was able to blend a little bit what I was doing. And I even this issue we're going to talk about today has some national security implications. So it's been something that I've definitely kept my toe in.
Well, I mean, to tee that off, I mean, I'm sure one of the things you learned when you were in your master's program, and certainly over the course of your career, is that the nation that is most prosperous, that is most economically prosperous, economically stable, is the nation best able to defend itself, isn't it?
100% correct. And that was what, for example, the TRIA program I just referenced was all about. It was, there was a lot of people don't remember this or even we're not necessarily even aware of it post 9/11, but we had some serious economic dislocation.
Right.
Particularly in major urban centers that were now risk targets in a way that we hadn't understood.
It's interesting. I'm going to take a very different direction, John, and I promise you we're going to come back to this important issue.
Yeah.
But, it's one of those things where I'm the guy who, when I sit, and I love my Marvel movies, but I'm sitting there and watching the rampant destruction of Manhattan. And I'm like, well, what who pays for this, right? Where do we go from here? I just had a conversation with some guys from a nonprofit called Global Shield, and they're thinking about this stuff quite a bit. But this is clearly what we're talking about, isn't it? Do you have the same reaction when you're watching a Marvel movie?
I'll do you one better. I immediately say, oh man, the insurance company is going to have to pay crazy amounts of money. Although who knows? Maybe they have superhero exclusions in their policy.
Maybe.
Yeah.
But I mean, but that's just it, right? There are these real world consequences, when these things happen, and that's I guess the other part of it, because you and I had a conversation a couple of weeks ago, and I think we both expressed the fact that one of the things that we like to do is sit around a table with a group of people and work on solving problems, because that's what this is all about, right? This is all, and when you were with NAMIC, I mean, you're talking about, we're always talking about very real, very personal problems, certainly when you're talking about making people whole in the wake of catastrophe. And this is a good segue, because our legal system is geared in a way so that folks who have real harms done to them can try to get some compensation, but we should not have created a system where it becomes a massive casino, should we?
I think you hit the nail on the head there.
Yeah.
It's our justice system is about adjudicating disputes between citizens and businesses, and while not perfect, the ideal it strives towards is achieving a measure of justice for the citizens of the United States. This was recognized, by the way. This is not a solely United States thing. This was the entire Western tradition of jurisprudence. We recognize this fact and strove for that ideal for hundreds of years. I mean, there were English common law principles that have funny names like barratry and maintenance and champerty, and all of these things relate to the idea of you do not use the justice system for profit. That's not what it's for. And so adhering to those principles was the tradition in Western jurisprudence for hundreds of years, as I said. So it really is
John, as I'm fond of saying, the way just law, right? Just law is born out of the intersection of the expression of rights. And when there is a conflict, the law is supposed to weigh down more heavily on the side of the party that is most aggrieved, right? I have a right to wave my hand around in a wild interpretive dance under my right to free expression. But when the back of my hand crosses the bridge of your nose, right, that's not legal, right? That's not protected because you're the party that is more harmed in all of this. And not that we need to get all philosophical in that regard. So let's talk about Americans for Litigation Tax Fairness, what that means, what's going on, and how do we get here? This is the widest ranging part of the conversation. So get deep into the weeds if you want, please.
Sure. So I hope that listeners and viewers will maybe stipulate the idea, the very, very high level broad idea that the United States is known as one of the most litigious societies in the world. Right. A very robust legal system and litigation environment. Very challenging, for businesses and individuals in general. You have to walk very carefully, and in many times you can get kind of swept up in lawsuits that are expensive and costly, and sometimes it feels like, why are we doing this? This doesn't make a whole lot of sense.
All you need to do, John, is read through the legal advice subreddits that are out there, and you see all of these questions about various, I got this in the mail. Someone is claiming X, Y, and Z. Yes, it's crazy.
Yes, and how many class action notices have you received? And then you get your $14 check, and everybody's
literally got an email yesterday about tickets to the theater in New York that I bought. And it said, if you went to these three theaters between, March of 2023 and March of 2024, you get, no joke, because we went to see a show, we get a whopping $7 in the
yes.
But my wife turned around and said, well, I don't want to turn around and do something that's really going to hurt the theater. I mean, I'm happy to pay the $3.50. What I don't want to do is have the theater go out of business because of these class action lawsuits. Go ahead.
Now, Andrew, you already alluded to the question: who pays for all this, right? And I think your wife had exactly the right reaction, which is, well, okay, I want to make sure we're not causing harm on the back end for $7 for me for something I didn't even know I was harmed by.
Right.
Right. So
Right.
in any case, assume that everybody will stipulate that we have a very litigious society.
Yes.
There are different things and many different ideas in the space where at some point people have called it just lawsuit abuse. People just lawsuits were always intended to be a measure of last resort when you could not reconcile with your neighbor or your colleague or your business partner. And people are using it as a means of first resort now. I mean,
right.
it's fairly clear. So, so there's lots of stuff we can talk about in the lawsuit abuse category. What my organization is focused on is something that it's brand new to American shores as of about 20 years ago, at least in the form it's taking now. It's something called third-party litigation funding. Now, yes, what we mean by this is not just any old third party that helps pay for a defense lawyer or a lawsuit or anything. It's not. And so when people hear it, sometimes they think, oh, well, I helped my son pay for his, criminal defense or drug charge. That's a third party paying for, to help access the justice system or utilize the justice system. That's not really what I'm referring to. TPLF is a bit of a term of art. And so it basically is an uninvolved third party that is funding litigation in pursuit of a most times very large chunk of whatever the return in the form of an award or a settlement is. And so let's say I come to you, Andrew Langer, and I say, okay, I think you've got a claim here against your neighbor. I'm going to pay you to prosecute this case, and then you're going to give me half of whatever we get.
Wow.
And this is that's just a quick thumbnail of third-party litigation funding, and it is profit seeking and profit motivation. The folks that are doing this are they describe it as a new asset class, a complex financial product. And they certainly package and market it that way. But ultimately, this was just not done prior to 30 years ago, in the United States in particular. And it came to our shores. I actually was working on this issue for NAMIC, almost 20 years ago, when there were first just inklings that this was going on. One thing to note is that there's no required disclosure, mandatory disclosure in federal courts. And now a few states have updated some law, but you wouldn't know necessarily if there was somebody paying for a lawsuit.
But these are, we're talking specifically about instances in which we're talking about lawsuits in tort, right? We're talking about someone who's alleging something that there's damages. We're not talking about public policy. And to a greater extent, we're not even talking about, I mean, we could talk a little bit about sort of the domestic funding of this, but we're really sort of pulling it back and talking about foreign investors in this. But, they think there's some difference, right? Or is there not?
No. And when I say third party litigation funding, and we'll just say for profit is a new thing. Look, we've had particularly conservative cause litigation, for example, organizations, nonprofits that have been doing this kind of thing where they take money from third parties and pursue litigation against say government agency or something. This is not new. This has been going on for a long time. It's been a tool in the public policy toolkit for cause
and there's not a direct financial relationship if donor let's say, let's not even say on the conservative side, let's say on the leftist side of it, right? Donor X gives to the some kind of progressive civil libertarian organization to pursue public interest litigation, or even if on specific pieces of litigation, it's not as though that person is going to directly benefit. They may indirectly benefit, right? I mean, there may be, let's say that there's some kind of a corporate interest that gives to a civil libertarian organization, let's say to protect the ability of a news entity from continuing to report on the news, right? There may be some kind of benefit there. But it's not as though they're getting a massive cash payout from this, right? That's
a major difference, right? It's in pursuit of a ideological position or a public policy that may, you're right, it may benefit the
answering a public policy solution, some kind of thorny question. Direct. I'm sorry. Go ahead.
Absolutely, no, it's fine. And but this is different in character for sure, because it is pursuing only those court cases that can, in their view, return,
right?
Deliver an ROI on their investment. And so it's just a fundamentally different thing. Now, what you alluded to, we started digging into this. There's no disclosure. I've alluded to this.
Right.
It's very difficult to get a handle on how big the market is. We now have some organizations that try to do market surveys, and some estimates suggest, and I think this is low, that this market has exploded to $16.1 billion in assets under management. I think it's probably closer to 25, because the 16 is just in the commercial, business on business lawsuits. Mass torts, class actions we talked about. I think if you added all the funding that went into all of that, you're talking about maybe 25 billion.
All right, John, but here's the thing that I don't get me, right? When I think of assets, I think of a building. I think of a boat. I think of a train car. I think of an oven in a pizza bake shop, right?
Yep.
Something that's sort of a tangible. I mean, even if we're talking about stocks and bonds, how can the funding of litigation, how can that be considered an asset? And as a secondary question, who regulates that as sort of an investment opportunity?
Well, it's a great question, and nobody necessarily.
Okay.
So there are some publicly traded funds that have SEC regulations, right? So I'm not suggesting there's no regulation on that front. But you could do this as an individual, and if there's no disclosure, in theory,
sure, right? I get that's
it wouldn't
true.
be regulated. So it is very unregulated. It's opaque. The marketplace is opaque. I think you hit the nail on the head, though. Traditionally, you could imagine, say, a law firm taking an operating loan, to prosecute. Say we need the resources to prosecute this case because it's going to take 5 years.
Sure.
And they get an operating loan, and they have to pay that back. Well, that's interest on a loan. That would be ordinary business income for whoever's lending them the money. What's happened is that the entire marketplace has moved in the direction of creating complex financial agreements that essentially they're known as prepaid forwards, and they create an almost derivative product. I don't want to get too technical here.
No, don't get technical, because I think that's enormously helpful here.
Yeah, it essentially creates a derivative-like product. Not to get too in the weeds. No, however, I would point out that this has just been asserted by the funders that this is a legitimate use of that type of contract, and that it is actually a capital asset. To your point, it doesn't waddle or quack like any of the other capital assets we understand. And I would argue that it's a totally illegitimate assertion of capital gains treatment, because you're talking about what is a portion of an unadjudicated claim of harm. And that's if it's unadjudicated, it's different than if you had a settlement, a structured settlement that you then sold to me.
Sure.
That you have a legal obligation.
Oh, I get it. Believe me, I got the theme. I got the theme song, the jingle going through my head right now about my structured settlement.
That's a different animal. It's been adjudicated. This is just a claim of harm,
right?
And that's not an asset.
Let me take it. Okay, because I mean, all right. I'm just trying to find analogs here, and this is a discussion, right? If I'm a business owner, I can invest in a fighter, but a fighter has skills. Those skills can be evaluated. I nominally, supposedly, theoretically, I guess, could invest. If I'm a business and I'm a businessman, I can invest in a series of high stakes poker players, theoretically, but I couldn't call for, hey, come and invest in my poker player fund, right? We know casinos are regulated, and they should be, right? There's a reason why there's a high level of scrutiny in the casino operations business. And this is not, listen, I'm someone who likes to throw the bones at a casino as much as anybody else. But I'm not a professional at it. I don't consider myself a professional, and I wouldn't want somebody to invest in me. Understanding that somebody can invest in a casino, which is a highly regulated industry, you can't turn around and invest in a gambler. I mean, not that I want to give anybody ideas, but that's sort of what we're talking. Is that kind of what we're talking about here in a way? I mean, in the most abstract.
It's an interesting analog. I haven't thought about that.
I know it's a weird thing, and it's because I'm just 20 minutes into my caffeine this morning.
That's right. Well, that's okay. So I don't know if it's exactly apples to apples, but I think what you're pointing at is is this notion that, I would also say this. It's not clear that your winnings would be treated any differently than the gamblers. Let's say you did.
Right.
And that's actually
point.
Getting to the crux of what Americans for Litigation Tax Fairness is focused on.
Yeah.
So what's happened is, the gambler, let's say you give him, because I'm sure this happens off the books, you give your buddy $500 who's going to Vegas and you say, hey, cut me in on whatever.
100%, right? I'll stake you for $500. Yeah. I want X percentage of your winnings.
Yeah. But then when, assuming everything's above board, when your buddy files his taxes and pays on his share, you're filing your taxes, paying on his share. It's the same income. It's ordinary income, or it's the same type of income. What's happening is these guys, the TPLF funders are creating these financial agreements, and what happens is at the plaintiff's table, it creates a disparity in who's paying at what rate. So a plaintiff, just for clarification,
this is really important, John.
Yeah, not every award or settlement or all of it is taxable, right? So if you have $600,000 in medical bills and you get paid that back, that's not going to be taxed. Right. But there are portions of awards and settlements that are taxed. When they're taxed, it's taxed at the ordinary income rate.
Got it.
Same thing for the plaintiff's attorneys. Now, these guys will have their attorney's fees. It'll go through the LLC for their firm or whatever, but they then pay their share of the firm's attorney's fees at the ordinary income rate. And then you've got this investor who is claiming that what they're doing is investing in a capital asset. To your point, that's already a little squishy, I think, or questionable anyway.
Right.
That gets this preferred capital gains rate. And so you've now got the actual victim of the harm at issue in the court case has to pay at a higher rate than an uninvolved third party.
Right.
Now, let me just, you alluded to this earlier, and I want to make sure we get to it. That treatment not only creates that problem, but the capital gains treatment allows foreign investors to create a situation in which they pay no U.S. taxes.
Right.
And we couldn't figure it out as we were, a lot of folks that were interested in this and thinking about it. Why does there seem to be so much foreign money? One of the most notorious funder firms, which is based over in Guernsey, it bragged in a 2018 press release that they had an unnamed sovereign wealth fund that had just given them $1 billion to invest in litigation. We couldn't figure out, there was all these, they're based overseas. There were all these sovereign wealth funds that seemed to be active, and what's going on here? Well, when we figured it out, it's a tax advantaged investment in the United States because they can declare as capital gains, it is not effectively connected income, and therefore no U.S. tax rate. Now, that's to inspire. By the way, the structure, I'm not taking issue with the structure of the tax code from the perspective of encouraging foreign investment. If you want to invest in a factory in the United States, it creates jobs and a tax base and all of these things. Productive investment.
Well, no. You're investing in capital. I mean, this is the thing that gets me. Capital has a very specific definition. And this is not capital. In fact, if anything, it is anti-capital, right? I mean,
yes, I like to think of it as incentivizing productive investment versus extractive investment, and this is extractive.
Oh, I love this. Expand on that, because that is an excellent point.
Well, yeah. So the productive investment we're trying to encourage, that President Trump has been touting that he's bringing, to the United States, is all about what you just described: investing in capital that can then translate to jobs and a tax base and all the good things that come along with it, contributing to the U.S. economy. In a lawsuit, you may be making somebody whole for damages, but when you get into and what we've seen, just crazy inflation in verdict sizes, unreasonable verdicts and judgments. When you start getting into that, what you're doing is you're sucking money out of a U.S. business, and you're giving some to the plaintiff and the attorneys, but in many cases, well over half of it is going to these investors, and they're just taking it overseas and not paying any tax on it.
And it creates, it is the one-off on what we talk about in terms of regulatory costs, right? We know that the direct regulatory costs, right? It gets into the whole concept of the broken windows theory of regulation. The folks who say more regulation creates economic opportunity, right? Because it's like the kid running through the strip mall and breaking every window, well, that puts the glaziers all in business. Whereas we know that costs insurance, it costs the businesses themselves. It actually is siphoning money away. It's extractive. I love that term because
extractive. And look, we've started this conversation talking about insurance, and you just alluded to it again. Insurance at the end of the day is a lagging indicator of all of the costs that go into facing and handling risk in the economy. And so we can complain about our insurance rates all day long, but the reality is they're adjusting to the risk that they're seeing in the marketplace from prior years. And so the folks that have responsibility on the liability side, who have seen this dramatic increase in the number of court cases, the severity of court cases, that all translates into what you and I pay in our premiums on all of our insurance policies and everybody. I spoke to a rideshare company that suggests that in most major urban cities in the United States, that 40% of your fare is going to insurance now, because of being targeted by predatory lawsuits.
And it's interesting, right? Because I went down this road with the whole patent troll issue. As a podcaster, was a huge thing. But I want to take it in a slightly different direction, because we started off by talking about the importance of a strong economy, a prosperous economy. We now know, you have a master's in national security studies. We understand now that the face of warfare is very different. Yes, as we're blowing up, drug cartel ships, off the coast of Venezuela, there's that aspect of it too, in dealing with the South China Sea, et cetera. But the reality is there is so much that is being done to make the United States weaker that is not overt military action. When you talk about sovereign wealth funds of foreign nations funding massive amounts of litigation that is very opaque, that is extractive, right? Pulling stuff out of the economy. There is a massive national security aspect here, is it not, John?
Yes, there's no question about it. And in fact,
time out. So even if we assume for a moment that it was okay to do this domestically, we'll talk about that in a minute. The fact that there are foreign actors doing this presents a whole other dimension that should raise our concerns. Go ahead.
Yeah, I totally agree. And there is there are examples of, folks that are clearly not necessarily our friends or have our best interests at heart. And there's all sorts of different reasons for this, but the CCP has been tied to groups and funds that have been funding litigation against chip makers and tech companies in the United States. Now, there are plenty of theories around targeting intellectual property through the discovery process and through all of these things, where it's another way of stealing, U.S. business and trade secrets. Frankly, even if that's not at issue, isn't it a good thing to tie up enormous American leading companies in certain industries that they're competing with? So.
But John, of course, we could turn around and we could just go and sue Chinese companies for doing this, right? Because we know that the Chinese courts will treat us all. Sorry, go ahead.
Yes. Well, I will. I probably won't be funding that particular lawsuit in China.
I don't understand. Yes, right. It's not. It's certainly not an asset. It's certainly not an investment, right? We're gonna. I need you to invest in my lawsuit against the Communist Party of China.
Yeah. Well, I don't hold out a lot of hope on that. But look, and even there are other national security interests of the United States. Take Russia and Ukraine and the situation over there. We have attempted to bring the Russians to the table through economic sanctions and means, pretty much exclusively. But and that's been a huge focus. Well, we had, I think it was Bloomberg reported over a year ago that sanctioned Russian oligarchs have been using the global litigation funding marketplace to get around sanctions because it's very hard to track all of this money and figure out where it's going, and there's no disclosure. So even those national security considerations that aren't direct, enemies suing our companies, it's a big deal, and we have got to get a handle on it. There's no question about it.
Let's turn our attention back to the domestic part of it, because the practice of law. Now, neither you nor I have JDs.
Correct.
So some will argue that's a good thing or a bad thing, whatever. But you and I both have, I think, an understanding. We've both spent enough time in legal adjacent circles. I've worked for some very talented lawyers over the years, 2 major law firms. And there are certain ethical practices that have to be followed. This gets into what you were talking about in terms of the issue of barratry. We specifically, there are ethical rules preventing lawyers from going out and soliciting. But you've been talking about, and I want you to explain this a little more, the idea of law firms setting up, or hedge funds or investment, operations, setting up law firms or investing in whole law firms to do this. I think there's one out in Tyson's Corner now. So talk about this in the context of ethics and in the context of barratry. Talk about barratry. Tell us all a little bit what barratry is.
Sure. Well, again, it's this. It's all tied into this idea that we don't want to commoditize and financialize our justice system, because ultimately it's bringing in interests and positions and dynamics that corrupt the traditional pursuit of justice. I have plenty of examples here. What you're referring to, maybe the next frontier. I'll get to that in a minute about direct investment. But we have examples of the funding community writ large loves to lead with this. We're silent investors. We have no influence over the court case, or if the plaintiff wants to settle, we're just not involved in that. And the reality is that, you are beholden to your paymasters no matter what. I mean, that's just a fact of life. And if the funders are the ones paying the attorneys on some level, creates this new dynamic where they do have to answer to the funders.
Plus, at the end of the day, right? I mean, it just strains credulity. I'm going to invest in business X, and I'm going to have no influence over. I'm going to have huge amounts of money that are changing hands with an expectation that I'm not going to have any. Sorry, go ahead.
No. Can I give you a perfect example
Please.
of this? This was I feel like we've gone all the way through the looking glass every time I use this example.
Right.
So, meanwhile, I already alluded to this very. The infamous funder, one of the biggest ones, Burford Capital, based in Guernsey. They actually were on a 60 Minutes episode several years back. And while that aired, and the CEO of Burford Capital was claiming, we don't get involved, we're silent partners, that's just not something we do. His fund, Burford Capital, was suing a plaintiff that they had funded, Cisco, the food distribution company, because Cisco wanted to settle, Burford Capital didn't, and they sued Cisco to take over their basically antitrust case.
Wow.
And the judge allowed them to take over. This litigation is still going on. The named parties are now Burford versus Cisco. Burford versus a collective of protein producers in the United States. But the actual plaintiff wanted to settle. Burford said, not good enough.
And more to the point, what is the specific harm to Burford that Burford is alleging? Like, we get the harm to Cisco, or alleged harm to Cisco. We can make that argument.
The alleged harm is now financial in nature based on the TPLF agreement with Cisco. That is the whole linchpin that they use to insert themselves.
All right, we go to Cisco, or we go to Corporation X, and we say, hey, you've been harmed by this. Or Corporation X comes to us and says, we've been harmed by this. We want to have our day in court. They say, okay, we've figured out what the number is where we want to reach a settlement, and somebody else says no, and all of a sudden they're now. I mean, you're right. It is through the looking glass is exactly where it is. Okay, sorry, go ahead.
No, I was just agreeing.
So what are we talking about? In terms of the remedy here, because that's there's a lot of stuff going on. What's the solution to the problem? What are we looking at?
Look, so writ large, I think there are probably several different things that need to happen. At a bare minimum, the question of disclosure, allowing a defendant to understand if there's another party at the plaintiff's table that has a financial interest. It's just common sense. This needs to happen. So disclosure is one piece. What my organization, Americans for Litigation Tax Fairness, is focused on is addressing what we think is this kind of inappropriate incentive that is built into the tax code. And so here's what we don't want to have happen. There are some projections that this market could double in size within about 5 to 7 years. So
Sure.
you're looking at $32 billion.
As Willie Sutton said when he was asked, why do you rob banks? Because that's where the money is. Go ahead.
That's where the money is. Yes, the returns are good. It's a non-correlated, asset class. They describe it. So look, part of the problem you're going to have then, and I would submit we're already, speaking of through the looking glass, we're already way past this problem now. But imagine doubling the size of the amount of capital that's sloshing around our courts. Do you really think, let's just kind of play with some hypotheticals here. Let's just assume that every single case being funded right now is entirely meritorious.
Right.
Do you really think that just because the capital doubles, the number of meritorious cases is also going to double? And of course, no, those things are unrelated. But if you have all that capital sloshing around, what's it going to be doing? It's going to be chasing returns. What is that going to look like? It's going to look like increasingly dubious spaghetti against the wall style litigation that does nothing but tie up the courts and drive up costs. So
that are already tied up with other kinds of litigation, some of which much more meritorious. Go ahead.
Yeah, exactly. So if we remove the tax advantage status and put it on par with the plaintiffs, so look. If you can still do this, what our coalition is pursuing is a change. There are bills that have been introduced in the House and the Senate called the TPLF Act. Essentially, it would put on par the funders with the plaintiffs, where they have to pay kind of at the same rate. And if you did that and remove this incentive, what we think that would do is tighten the underwriting and the willingness to engage in a actually very helpful manner that would lead to funding. You would have to double down on trying to figure out meritorious cases versus not meritorious cases because you have your ROI calculation has changed. And right now we're just saying, look, there's no risk on the tax side, especially if you're overseas. Come on and play in our courts. And we just, at a bare minimum, we're trying to correct that tax treatment. And we think it's not going to solve the issue. It's not a silver bullet. But it seems like a common sense, we need to get this thing done, close this kind of loophole that foreign funders of litigation have. So.
And again, to be perfectly clear, to state it, this is not designed, and if done in this way, right, this is not supposed to get rid of public interest litigation or get at the other part of this. Right now, I'm someone who fundamentally believes in the right of a donor to give to any kind of a 501c3 or 501c4 organization anonymously, right? That's the essence of who we are, right? Donor privacy is paramount. There's a whole other aspect of this. And again, right, I think it actually goes along with the same reason why, something? I'm enunciating this, John, so stay with me for a second. When you cross the line from engaging in policy and voicing your opinion on policy to trying to influence an election, that's where the disclosure laws change, right? That's why we have a whole sweep. I'm not going to suggest that you be familiar with 501c laws. But there's a line that gets crossed where all of a sudden it's regulated by the FEC as opposed to the IRS. So we recognize that. And because there are those exceptions for the fundamental manipulation of that landscape, there should be some kind of a way of looking at this. I'm sorry. Go ahead, John.
No, I think you're describing sort of traditional public interest litigation from the right, from the left, whomever. That is not something that my organization is seeking to address. We do not want to disrupt that in any form or fashion. I would just hasten to point out that traditional funding model, the legislation that I described that this coalition supports, wouldn't disrupt that in any form or fashion. If a 501c organization wants to pursue litigation and it's gotten money from donors and it goes and does that, that if this bill passed, nothing about that situation would change tomorrow.
Right.
Nothing. Like it wouldn't impact it in any way.
But by the way, in the same token, right, we would be looking very carefully if someone was funding public interest litigation and directly personally benefiting from it, right?
Yeah,
Imagine
so.
again, imagine if conservatarian donor X, let's say you have a pair of brothers who have been interested in public interest issues, public policy issues, their entire career. One of them may have run for higher office at one point, and they've funded huge amounts of organizations. You can bet that there would be a massive hue and cry, or flip it around, right? If major donor, and this is something I've talked about, right? Tom Steyer. Tom Steyer is a major progressive donor. When Tom Steyer gives money to candidates, there is a relationship between what he is trying to extract from the public treasury at the back end. So this has no impact on the ability of these two brothers to go and pursue these things. But if they were trying to personally benefit from it, yeah, we'd have a problem, wouldn't we?
Yeah, I think if they were suing competitors and taking half, or paying somebody else to sue their competitors and taking half of the money, there might be a different conversation there. I would hasten to point out, look, there are two. I should start by saying, if this TPLF Act passed and the tax treatment were corrected, nothing about that would prevent anybody from pursuing a third-party litigation funding agreement tomorrow. Like, it doesn't disrupt it at all. It just changes the tax rate. If you're a domestic individual already paying on, capital gains or whatever, you're talking about a 17% increase in your taxes. Okay, I'm sure you don't like that. But
and by the way, Americans for Tax Reform on board with this.
Yes. Well, yeah, it's correct. Yep. They understand that there's a tort tax on American consumers
100%.
where we all pay. I think latest estimates are north of $4,000 a year just in a tort tax that's based on the U.S. justice system's litigation profile. So I think they see it as a way to raise this tax in order to cut taxes for everybody across the board. I don't want to speak for them, but and they support it as well. But look, so there's that fact that you can still pursue the third party funding of litigation, even if your tax rate is a little higher. It still can happen. But two, I think it's important. The lead sponsors legislatively put in the bill an even further exception from this tax regime for 501c organizations that use a different model that maybe does have a specific donor giving it's called a recoverable grant model, where a donor gives a grant for pursuit of certain litigation that turns out does have some damages associated with it. That person can then they recover the grant. And then also, I think in many cases, they apply a small interest rate, return.
Sure.
That scenario, that structure is exempted under this legislation.
Well, that's an important point. I find that very hinky, the idea that someone would go and say, hey, I'm going to give you money to do this and then want to be paid back. It's a very strange way to sort of deal with nonprofits. Jon, listen, before we let you go, what are you doing when you're not doing your public policy work? Man,
it's a great question.
Thank you.
I visit the gym quite a bit. I like to lift weights. I wish that would be obvious just by looking at me, but sadly it's not. Yeah, no, it's a good release. Helps me think, when I'm lifting heavy things in the gym.
Sure.
I also have three young kids, so that is about all I have time for, to be honest.
Got it. Yeah. So the gym is the only time where you could be in your own head and in your own space. Yeah, I get it.
That's exactly right. Exactly.
Yes.
Right.
Oh, good Lord. Henry David Thoreau had Walden Pond, and you have the gym. Jon, how do folks find out more about the good work you guys are doing?
Absolutely. Well, you can go to lawsuittaxfix.com is sort of the central hub. And otherwise, we are out there. There are a lot of folks that are commenting on this. You can go look up the TPLF Act and see how it's doing on the House and the Senate side, et cetera. So.
Excellent. Lawsuittaxfix.com is the website. Jon Bergner. He's the executive director of Americans for Litigation Tax Fairness. See, I got it right there.
You got it.
Listen, I want to thank you all for joining us on yet another episode of the Federal Newswire's Lunch Hour podcast. Check us out. Check us out on YouTube. Check us out on the many fine podcast platforms. Follow us on X at the Lunch Hour Pod. You get clips, you get all kinds of things. And if you're not following me, by the way, I never say this, but follow me as well at Andrew_Langer on Twitter. I still call it Twitter. Everybody else, I'll say it's X. But thank you all for joining us. Enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream.